Good morning, students. In the current session of environmental law, we shall learn about the legal provisions of the Water Prevention and Control of Pollution Act of 1974. Previously, in our session of environmental law, we have discussed about the constitution of Pollution Control Board and the qualification of the members of the same. Now we will look into the legal provisions concerning the disqualifications. Section 6 of this act, subsection 1 says, no person shall be a member of the board who, clause A says, is or has at any time has been adjudged insolvent or has suspended payment of his debts or has compounded with his creditors or is of unsound mind and stands so declared by a competent court or or has been convicted for an offense which in the opinion of the central or state government, as the case may be, involves moral turpitude, or is or at any time has been convicted for any offense, for an offense under this act, the Water Prevention Control of Pollution Act, or has directly or indirectly by himself or by any partner any share or interest in any firm or company carrying on the business of manufacture, sale, or hire of machinery, plant, equipment, apparatus or fittings for the treatment of a sewage or trade effluents, or is a director or a secretary, manager, or other salaried officer or employee of any company or firm having any contract with the board, pollution control board, or with the government constituting the board, or with local authority in the state, or with a company or corporation owned, controlled, or managed by the government for carrying out of sewerage scheme, or for the installation of plant for the treatment of sewage or trade effluents, or has so abused his position that in the opinion of central government, or as the case may be the state government, he has abused his position as a member, as to render his countenance on the board detrimental to the interest of the general public. He has abused his position so much so that if he continues, or the person continues to be on the board, it will be detrimental to the interest of the general public. So these are the grounds on the basis of which the person can be removed. Okay, now what is the procedure? Subsection 2 says no order of this such disqualification of removal or removal, shall be made. So the person will not be removed by the central or the state government unless this section says unless the member concerned has been given a reasonable opportunity of showing cause against the same. So again, principle of natural justice is applied, that the person needs to get, so there's a procedure. So first a reasonable opportunity needs to be given to the person concerned. So he shows his cause, and then a order further can be moved. Now subsection 3 says, notwithstanding anything contained in subsection 1 and 7 of the of section 5, a person, a member who has been removed under this section, that member shall not be eligible for renomination as a member further. Okay, so along with this you can also look into section 7, which talks about vacation of seats by member, and 11, which talks about constitution in board not to invalidate acts of proceeding, and 9, which talks about constitution of committees. Okay, now we will move further towards the powers of the board. Now let's look at the functions of the pollution control board. So chapter 4 section 6 talks about the functions of the central state pollution control board. Section 6 says that section 6 enumerates the functions of the central pollution control board, and subsection 1 says that uh, the subject to the provisions of this act, the main function of the central pollution control board shall be to promote, it will be a binding duty for them to promote cleanliness of streams and wells in different areas of the state. Okay, so now if we look at the major functions, if you look at the legal provisions given under section 16, you see that the major functions are as follows: to advise the central government on matters relating to prevention and control of water pollution, to coordinate the activities of the state pollution control board, to resolve the disputes which are there, if at all it's there amongst them, to provide technical assistance and guidance to the state pollution control board, carry out and sponsor investigations and research relating to the problems of water pollution, so that they can finally prevent, control, and abate water pollution, to plan and organize training of persons engaged in programs so that they can prevent, control, and abate water pollution, to organize comprehensive program regarding prevention, control, and water pollution through mass media, and to collect, compile, publish technical and statistical data relating to water pollution and measures devised for effective prevention, control of water pollution. Also, they have to prepare manuals, codes, guides relating to treatment and disposal of sewage and trade effluents, and disseminate such information connected therewith, to lay down, modify, or annul these standards for a stream or well, and to plan and execute a nationwide program for prevention, control, and abatement of water pollution, to establish, recognize laboratory or laboratories to enable the Central Pollution Control Board to perform the above functions, and to perform such other functions as may be prescribed. Now let's look into the functions of the State Pollution Control Board. Section 17 of this Act of Water Prevention and Control of Pollution Act of 1974, it talks about the functions of the State Pollution Control Board. Subsection 1 says that, subject to the provisions of this Act, the functions of a state board shall be, Clause A says, to plan a comprehensive program for the prevention, control, and abatement of pollution of streams, wells in the state, and to secure the execution thereof, to advise the state government on any matter concerning prevention, control, or abatement of water pollution. Clause C says, to collect and disseminate information relating to water pollution and prevention, control, and abatement thereof. Then to encourage, conduct, participate investigations and research relating to problems of water pollutions and prevention, water pollution, prevention, control, or its abatement. To collaborate with Central Board in organizing the training of persons engaged or who are going to be engaged in programs which are related to prevention, control, or abatement of water pollution. To organize mass education programs relating thereto, to inspect sewage or trade effluents works and plants for the treatment of sewage and work effluents, to review their plans and specification or other data relating to those plans, uh, relating to plant setups for the treatment of water, works for the purification, and the system for disposal of sewage or trade effluents, or in connection with the grant of any consent as required by this Act. To lay down, modify, or annul effluent standards for the sewage and trade effluents, for the quality of receiving water, uh, not being water in an interstate stream resulting from the discharge of effluent, and to classify water of the state, to evolve economical and reliable methods of treatment of sewage and trade effluents, to evolve methods of utilization of sewage and suitable trade effluents in agriculture, to evolve efficient methods of disposal of sewage and trade effluents on land, as are necessary on account of predominant condition of scant streams flow that do not provide of any major part of the air the minimum degree of dilution. To lay down standards of treatment of sewage and trade effluents to be discharged into any stream while taking into account the minimum fair weather dilution available in that stream and tolerance limits of pollution permissible in the water of the stream after the discharge of such effluents. To make, vary, or revoke any order for the prevention, control, and abatement of discharge of water into streams or well, requiring any person concerned to construct new systems for the disposal of sewage, trade effluents, or to modify, alter, or extend any of the existing system to adopt such remedial measures as are necessary to prevent, control, or abate water pollution. Also, to lay down effluent standards to be compiled with by persons while discharging, by causing discharge of sewage or sewage or both, and to lay down, and not only to lay down, to modify annual effluent standards for the sewage and trade effluents. Then to advise the state government with respect to the location of any industry, the carrying on of which is likely to pollute a stream or well, to perform such other functions as may be prescribed or as may from time to time be entrusted to it by the central board or state government. Subsection 2 says the board may establish or recognize a laboratory or laboratories to enable the board to perform its functions under this section efficiently, including the analysis of samples of water from any stream, well, or samples taken from any sewage or trade effluents. Now we will talk about section 18, which talks about the power to give direction. Subsection 1 says that in performance of its function, so it talks about the power of the central government. So the central board shall be bound by such direction in writing as as the central government may give it to it, and every state board shall be bound by such directions in writing as the central board or the state government may give it to it, provided that where a direction given by the state government is inconsistent with the direction given by the central board, the matter shall be referred to the central government for its decision. So, where subsection 2 says that where the central government is of the opinion that any state board has defaulted in complying with any of the directions given to them by the central board under subsection 1, and as a result of their default a grave emergency has arisen, and it is it becomes very necessary or expedient to do so in public interest, so it may by order direct the central board to perform any of the functions of the state board. If state board has defaulted in any of the functions, if they are not able to perform any of the functions which has been, or any of the direction that has been given to them by central board, then the central government can direct the central board to perform that those functions of state board, and those function of state board in relation to such areas for a period and for such purposes as may be prescribed under in the order. So subsection 3 says where the central government perform any of the functions of the state board in pursuance of a direction under subsection 2, the expenses, if any, incurred by the central board with respect to the performance of such person may, if the state board is empowered to recover such expenses, be recovered by the central board with interest at such reasonable rate as the central government may by order fix, from the date when a demand for such expense is made until it is paid, and from the person or persons concerned as area of land revenue or of public demand. Subsection 4 says For removal of doubt, it is hereby declared that any direction to perform the functions of state board given under subsection 2 in respect to any area would not preclude the state board from performing such functions in any other area in the state or any of its other function in that area. So it says that the subsection 2 of section 18, where the central government has directed central board to perform some of the functions of the state board in some particular area for a specific period of time, does not mean that the state board shall not perform any of its function. The state board will have to perform its other functions except for the functions in those areas where the central board is being directed. So there it does not preclude them from, it would not preclude the state board from performing such functions in other areas. Now let's look at the chapter 5, which talks about prevention and control of water pollution, under which section 19 says it talks about the power of the state government to restrict the application of this act to certain areas. So subsection 1 says, notwithstanding anything contained in this section, if the state government, after consultation with or on recommendation, so after consultation or on recommendation of the state board, pollution control board is of the opinion that the provisions of this act need not apply to entire state, it may, by notification in official gazette, can it may so it can restrict the application of this act to any such area or areas as may be declared therein as water pollution prevention control area or areas, and thereupon the provisions of this act shall apply only to those area or areas. Subsection 2 says each water pollution prevention and control area may be declared either by reference to a map or by reference to the line of any watershed or the boundary of any district, or partly by one member and partly by another. Subsection 3 says the state government may by notification in the official gazette alter. Clause A says that it can alter any water pollution prevention control area, whether by way of extension or reduction, or define clause B says or define a new water pollution prevention control area in which may be emerged with one or more water pollution prevention control areas or any part or parts thereof. So this section talks about the power that the state government has the power to designate any area or areas within a state as water pollution control area, are or areas after consultation or on recommendation of the state pollution control board, and the state government can also alter by way of extension or reduction any pollution control area or areas by notification in the official gazette.